Hello everyone, welcome you all to the course on corporate laws and governance. In this video, we are going to look at the Memorandum of Association. First, let's look at the meaning of Memorandum of Association. Memorandum of Association is a fundamental document based on which the structure of the company is built. Memorandum of Association tells the scope within which the company can operate with respect to the outside world. And it is a document that sets out the constitution of the company. Now, let us look at the characteristics of the Memorandum of Association. First, the Memorandum of Association have different forms, and these forms are specified in section 4 subsection 6 of the Companies Act. There are different tables, namely table A, B, C, D or E of schedule 1 to the Act. The companies that are limited by shares have to follow the form of memorandum that are specified in table A, and the table B is to be followed by the companies limited by guarantee without any share capital. Table C is followed by companies limited by guarantee with the share capital. Table D is followed by the unlimited companies without any share capital, and table E would be followed by the unlimited companies with the share capital. As I have already mentioned, the Memorandum of Association clearly specifies the objectives that the company has to follow, which defines the scope within which the company should operate. In case the company gets into those activities which are beyond the scope of the object clause of the Memorandum of Association, then that would be considered as null and void. And the terminology that is used to specify those activities which are beyond the scope of company's activity as doctrine of ultra vires. In case the company enters into a contract with a third party which is beyond their scope, then that contract would be considered as null and void. This can be understood by looking at the famous case of Ashbury Railway Carriage and Iron Company Limited versus Ritchie. Ashbury Railway Carriage and Iron Company Limited, as per its Memorandum of Association, can manufacture, hire and lend the railway wagons and carriages, and they can also get into the business of timber, iron, etc. They entered into a contract with Ritchie with respect to laying the railway tracks between two places in Belgium. In the due course, Ashbury Railway Carriage and Iron Company Limited could not perform the contract. That resulted in the breach of the contract. Ritchie went to the court, but the court observed that the contract that was between Ashbury Railway Carriage and Iron Company with Ritchie was null and void, as the Memorandum of Association never allowed Ashbury Railway Carriage and Iron Company to get into laying the railway tracks. That was considered to be the doctrine of ultra vires. and the company can alter the contents of the Memorandum of Association by passing a special resolution and getting that special resolution confirmed by the central government or the registrar of companies, as the case may be. Next, let's look at the contents of Memorandum of Association. Section 4, subsection 1 of the Companies Act deals with the contents of the Memorandum of Association. There are totally 5 clauses in the Memorandum of Association. They are the name clause, object clause, situation clause, liability clause, and the capital clause. Let's see each of these clauses one by one. First, let's look at the name clause. As per the name clause, every company, in the sense every private limited company, should have the terminology private limited attached to its name, and every public limited company should have the term limited attached to its name. Section 8 companies need not have the term limited appended to its name. The government company also should have the term limited attached to its name. And whenever the companies submit to the registrar of companies for the approval of the name, the registrar of companies should conduct a preliminary investigation of the name that had been submitted by the company, and they have to check that it is not misleading or it deceives the public with respect to the object class of the memorandum. Though they have to do the preliminary investigation, not that they will have to go for an elaborate investigation of the name unless and until the name appears to be unlawful or it looks like illegal or prohibited by any statute. For instance, if the name of the company falls under the Emblems and Names Prevention of Improper Use Act 1950, then the registrar of companies cannot allow the company to have such a name which is prohibited. And the registrar of companies should also check the name which may be misleading the public, and the approval should not be given to those kinds of names which would be misleading the public. Let us look at some of the cases where the name of the company had to be changed. In the case of Buttercup Dairy Company versus the Buttercup Margarine Company Limited, Buttercup Dairy Company was the plaintiff and Buttercup Margarine Company was the defendant. Buttercup Dairy Company went to the court telling that Buttercup Margarine Company Limited should remove the name Buttercup from its company, as it would be misleading to the public. In the sense, the public may think that these two companies are run by the same person. Moreover, both these companies fall under the same sector. The court felt that it would be misleading, and they asked the defendant to remove the name Buttercup from its name. Not that in all the cases that the court feels that the similar names would be misleading to the public. If we look at the case of Society of Motor Manufacturers and Traders Limited versus the Motor Manufacturers and Traders Mutual Assurance Limited, the court observed that the Motor Manufacturers and Traders Mutual Assurance Limited company need not change the name, as they felt they are in a totally a different sector, namely the financial services sector, unlike the plaintiff who are actually into the trade association company. And though the plaintiff wanted the defendant to remove change the name, the court felt otherwise. But if we take the case between Atlas Cycle Haryana Limited versus the Atlas Products Private Limited, the trademark for the term Atlas was with the Atlas Products Private Limited. Both these companies were run by the people who belong to the same family, but Atlas Products Private Limited felt that using the term Atlas as a brand to sell the cycles by another family member would mislead the public with respect to the management, and the court favored the plaintiff and they asked the defendant to remove the name Atlas. And this one thing should be understood was, like, the court only can tell the company to change the name when the name is misleading. It is up to the company. They cannot give direction. The court cannot give direction to the registrar of companies to get into the name changing process. It is the duty of the company to follow the rules and regulations as per the Companies Act to change the name, and this was understood in the case between Halifax PLC versus the Halifax Repossession Limited. Here the court ordered Halifax Repossession Limited to change the name as the name was resembling the another company's name, that is Halifax PLC. Though the court had given the direction, the Halifax Repossession Limited did not make attempt to change the name. When Halifax PLC went to the court again stating that the Halifax Repossession Limited is not changing the name, the court observed that it is up to the company to follow the rules of the Companies Act and change the name, and the court cannot give directions to the registrar of companies pertaining to this. Next, let us move on to the registered office clause or the situation clause. When the company goes for its incorporation, they would be submitting their Memorandum of Association. In the Memorandum of Association, the company should mention the state in which the registered office would be located. It is not mandatory for the company to give the complete address of the registered office in the Memorandum of Association during the process of the incorporation. But once the company gets the incorporation, the date of incorporation, they have to submit the complete address and the office location to the registrar of companies within 13 days from the date of incorporation. And the name should be displayed in a very legible manner. When I say name, it is the name of the company, and its complete address should be made available in all the conspicuous position. What are these conspicuous position? Yes, the name board should be either painted or affixed outside the office. The name of the company with its complete address, fax number, phone number, email ID, website, all these should be available in the letterhead. and the bills, invoices of the company, and the name of the company should be clearly mentioned in the seal, and even in all the negotiable instruments like the bill of exchange or the promissory note, the name of the company with its complete address should be mentioned. And if we when we say that the name of the company and its complete address should be affixed or painted outside the company, it doesn't mean it should be done outside the building in which the company is situated. There are chances the company would be situated in a big building where it would be a part of the building. In that case, it is not a compulsion that the name board should be put outside the building. The name board should definitely be there outside the office. If it is going to be a one-person company, the name one-person company should be there below the name of the company in all the documents. This registered office address is very important. The reason being, all the documents, all the legal notices would be sent only to the registered office of the company. Next, let us look at the object clause. Object clause clearly specifies the scope within which the company would be operating. It also talks about the limitation with respect to the power that the company has in terms of its activity with the outside world. Object clause actually protects the interest of the stakeholders, as the stakeholders will clearly know what and all the company are allowed to perform and what are all the activities the company cannot perform. That can be easily understood by looking at the object clause. And when we look at this object clause, the object clause would consist of the main objectives, incidental objectives, as well as other objectives. Main objectives are those objectives which form the basis for the formation of the company, and incidental objectives are the ancillary objectives which will support the main objective. The other objectives will contain those objectives which are not mentioned in the main objectives as well as the incidental objectives. There is no limit with respect to the type of objectives and the number of objectives that the company can have. Only thing is that the company cannot have the objective as that of the Section 8 companies. This is one thing. Another thing is the objective should, whatever the company sets for itself, should not be illegal. It should not be against the provisions of the Companies Act 2013. Whenever this object clause is, whenever one tries to understand and interpret the meaning of the object clause, one should do it in a fair manner. If we look at the case of Egyptian Salt and Soda Company Limited versus Port Said Salt Association Limited, the later, that is the the petitioner was one of the shareholders of the Egyptian Salt and Soda Company Limited, and when the Port Said Salt Association Limited wanted an injunction on with respect to the Egyptian Salt and Soda Company exporting salt from Egypt, and stating that it is beyond the scope of the Memorandum of Association. Actually, as per the Memorandum of Association, Egyptian Salt and Soda Company Limited was allowed to manufacture and sell salt within the country Egypt, and they were not, and there was no mention with respect to whether they could export salt from Egypt. They were not doing it because at that time the export of salt was the monopoly of the government, and as per the rule no company can export salt from Egypt. And when the government allowed the export of salt by the other companies, Egyptian Salt and Soda Company also started doing that. And the court felt that it is not beyond the scope of the Memorandum of Association, because there was no mention that the Egyptian Salt and Soda Company cannot export salt from Egypt to other countries, and they were not doing it because the government was not allowing it. So it was so whenever we read the object clause, it has to be done in a very fair manner. Next, let's look at the liability clause. The liability clause talks about the liability of the members of the company. The liability could be limited by shares, it could be limited by guarantee, it could be an unlimited liability. If it is limited by shares, that means the liability of the members are limited to the nominal value of any unpaid shares, if any, held by the members. They would be liable for the unpaid amount of the shares, if at all they hold one. If all the shares are paid up by the shareholder, that means they are not liable for any of the company's obligation. If the liability of the members are limited by guarantee, here the liability is limited to the amount that the members have guaranteed to undertake in the Memorandum of Association. So their liability is limited to whatever amount that they have specified that they would undertake at the time of the winding up of the company. If it is an unlimited liability, then the liability of the members are unlimited, and whatever be the legal obligations of the company, the members should bear it. So all these information would be stated in the liability clause. The next clause what we have is the capital clause. Capital clause talks about the maximum amount of share capital which the company is authorized to raise from the public. This is what we call it as the authorized capital or the nominal capital. There are other classifications also. We talk about subscribed capital, or we have the called in capital, then we have the paid up capital. So authorized capital is that capital, it is the maximum number of shares that the company can issue to the public. Issued capital is that portion of the authorized capital which the company tries to raise from the public. Subscribed capital is the amount that the investors have subscribed with the company, and called in capital are the capital which the company has asked the subscriber to pay for. Paid up capital is the amount that the investors have paid of the called in capital of the company. And when the company gets incorporated, at the time of the incorporation, in the Memorandum of Association, the company should clearly specify how much of the capital would be subscribed, or actually subscribed by the members who members of the company, and this should be clearly mentioned against each of the subscribers to the Memorandum of Association. All the subscribers to the Memorandum of Association should have at least minimum of one share against them. and the maximum is unlimited. Next, let's look at the alteration of the Memorandum of Association. As I have already mentioned that the contents of the Memorandum of Association can be altered, like the name clause, liability clause, capital clause, registered office clause. All these clauses can be altered by the company. Only thing, they will have to follow the procedures. Let's look at the procedures that the company has to follow when it alters the name clause. Yes, whenever the company wants to change its name, what it has to do is it has to pass a special resolution in its board meeting, and the same has to be approved by the central government. And once the approval is got from the central government after passing the special resolution, the registrar of companies would be issuing a fresh certificate of incorporation. But this approval by the central government of the special resolution is not needed when the company changes from public limited company to a private limited company, as well as from the private limited company to the public limited company. A company should not change its name, in the sense it is not allowed to change its name as per Rule 29 of the Companies Incorporation rules when they haven't filed their annual returns or the financial statements, or when they have with the registrar of companies, or when they have failed to pay the money back whatever they have borrowed, or when they have failed to pay the interest on the borrowed amount, then they are prohibited from changing their name. Now, let us see what are all the procedures that are to be followed when the company wants to change its registered office. There are different scenarios here. If the company is going to change its registered office within the city limits, as well as outside the city limits, but the jurisdiction of the registrar of companies remain the same, if that is going to be the case, what the company has to do is the company has to pass a special resolution. After passing the special resolution, within 15 days of such 15 days of passing of the special resolution to change the name, they will have to file the form INC 22 with the registrar of the company. When the company is going to change the registered office within the state itself, but when this particular change results in the change in the jurisdiction of registrar of companies, then the company should get approval from the regional director. Before the company goes to the regional director for approval, the company should publish they have to pass a special resolution, and they have to submit the special resolution in form MGT 14 with the registrar of companies. They will have to publish the notice in the newspaper, and when I say in the newspaper, it should be in two types of newspaper. One is the English newspaper, another is the newspaper in the vernacular language in which the register office is situated. And this they have to individually notify the creditors and the deposit holders and and all the debenture holders about the change in the register office. And they also have to submit, as I told, they have to submit the MGT 14 form with the registrar. with the registrar with respect to the special resolution that they have passed. Then when we look at once they have done this, they will have to seek the approval from the regional director. The regional director would be giving his or her approval within 30 days from the date of filing of this approval by the company. Once the company gets the approval from the regional director, the company within 60 days from the date of such approval should file the approval letter with the registrar of companies. After going through the approval and the special resolution, the registrar of companies would be approving the change of the register office from one registrar of companies jurisdiction to another registrar of companies jurisdiction within the same state. In case the company wants to change its registered office from one state to another state, what the company should do is, the company should pass a special resolution. They should file the special resolution with the registrar of companies in MGT 14 form. They will have to do that, but this special resolution should be approved by the central government, and the central government will be giving the approval after vetting, after checking whether there are no obligations on the part of the company to the creditors. Within 60 days, they would be giving their approval. Once the central government gives its approval, this approval letter should be submitted by the company to the registrar of the companies, and they should also fill the form INC 28 within the time period of 28 days from the date of getting the approval from the central government. And after scrutinizing all the documents, the registrar of companies would be approving the change of the register office from one state to another state. Next, let us see the procedures that the company should follow when it changes its object clause. The company should conduct an extraordinary general meeting, and the company should go for passing the special resolution. And when we talk about this special resolution, here the company should get the approval from the shareholders for changing the object clause, and this approval is normally got through ballot. And this details of this special resolution should be published in the newspaper if it is a public limited company, and the special resolution information should be put in the website of the company, and the company should clearly explain the reason for changing the scope of the company's activities. This will fairly give a chance to the shareholders to tell their disagreement, or it will give them a chance to exit the company if they are not convinced with respect to the alteration of the object class. And the company should also file MGT 14 form within 30 form with the registrar of the companies within 30 days of passing of the special resolution. Next, let us look at the alteration of the liability clause. In the case of liability clause, the company, whenever it wants to change, it has to pass a special resolution as per the procedure that has been mentioned in section 13 subsection 1 of the Companies Act. After passing the special resolution, the company has to file the special resolution with the registrar of the companies. Finally, let's look at the procedures that are to be followed when the company wants to alter the capital clause. When the company wants to alter the capital clause, what it has to do is it has to pass an ordinary resolution in the general meeting, and they will have to submit the E-form SH7 within a period of 30 days of passing such a resolution, and they also have to submit the altered articles and the memorandum of association. Whenever we talk about this alteration of the capital clause, what do we mean by this? This alteration can take many forms. It could be increasing the authorized capital amount. Authorized capital is the maximum share that the company can raise from the public. If the company wants to increase this authorized capital, they can do it. When they do that, that results in the alteration of the capital clause. Sometimes the company would be wanting to consolidate its shares, and they may be wanting to divide the shares, their share capital into shares of a larger amount than the existing shares. It could be about converting all its fully paid up shares into stock and reconverting the stock into fully paid up shares of any denomination. Even this also results in alteration of the capital clause. Sometimes the company may want to subdivide the shares in such a manner that it results in a smaller amount than what was fixed in the memorandum of association. The company may want to cancel the shares because the shares have not been taken or agreed to be taken by any person. So whenever the company wants to increase the authorized capital or want to consolidate, convert, subdivide or cancel the shares, they go for the alteration of the capital clause. Thanks for listening.